We are, and we're recording.
All right, terrific. Well, I am Todd Stevens, Chairman of the Pennsylvania Commission on Sentencing. This is our public hearing to discuss the working draft of the sentencing guidelines. And just want to make sure it's clear for the record and those participating. The title is exactly what is intended to be. This is truly a working draft, and our expectations are that we will receive feedback from parties all across Pennsylvania. We've had several hearings already and gotten a tremendous amount of feedback, both positive and negative, and that's good. And then I would expect that the commission will be considering all the comments that have been submitted throughout this entire process, and then be back with some additional changes and back with more proposals to consider down the road. I do see commission members, our vice chair, Judge Bernstein, is here, as well as another commission member, DA Sunday. Thanks both of you for joining. Do either of you have any comments you wanted to add before we get moving?
Nothing at this point.
Judge?
Nothing additional.
Okay.
Thank you.
Terrific. Yep. All right. Well, then we will we'll get started here, and we'll start with some comments from etc. Let's Get Free. Is there a representative from I'm sorry, Etta? Oh wait, it's almost a joke here, right? Etta Cetera. I apologize. I screwed up here. That's my mistake. So it is. Very nice to meet you, and I apologize for that. That oversight.
Oh, that's okay. Thank you so much. Should I start? I'm not sure how much time I have, or.
We're pretty flexible, so you've got however much time you need. Ryan, is there anything further she needs to do before she starts her testimony?
No, Chair. We can see and hear her. Thank you.
Okay. I was hoping that I wouldn't go first because, this is confusing to me. So I'll just introduce myself and then share a little bit what I can about what I understand. So my name's Etta Cetera. I live in Pittsburgh. I've been collaborating and working alongside of incarcerated people in Pennsylvania for about 20 years. I work a lot with people who are sentenced to life without parole. Most recently, I've been working with a group called Let's Get Free, the Women and Trans Prisoner Defense Committee. I also work at PAR as an online an on-call medical advocate, which is Pittsburgh Action Against Rape. So I'm working every week with people who are survivors of sexual violence. So just to give you a little situation of like where I'm coming from. And honestly, I got the 90-page document of the sentencing guidelines, and it's really over my head. I don't understand, I need a whole training and a workshop to really understand the processes. I'm not really a legal-minded, that's not my strong point. So it's intimidating to go first, and it is confusing, but one thing I do know is that perpetual punishment does not keep us safe. It does not keep us safe. It is not working. And that anything in these guidelines that further incarceration or further punishment, I don't agree with and I don't support, and those should be highly just thought about. I'm also really concerned with the racism that is interwoven in all of these processes. And it was suggested by the ACLU, I believe, to have a racial disparity committee or review, or to really understand how the impacts of these different guidelines will play out and impact different people. It's just thinking about prison being the punishment itself. Being separated from your loved ones, being separated from family, and then I know that there was an element of like programming somehow interwoven in all of this. And I know that people with life sentences are forbidden from participating in programming. And this is, I don't know how much this commission has control over it, but it's really, I actually think it's cruel and unusual punishment to sentence someone to these very excessive sentencing and then cut off any like real opportunities for growth and change, while these people are, the people with the excessive sentences are so much the fabric of that really supports other people in the prisons, their leaders, and they are coming home because we are working on bringing people home, and I believe they are going to come home. So the idea that like these people are just beyond redemption, don't deserve resources and access to better themselves because they won't ever come home. I'm here to tell you that we are working on making it so people do get second chances and are able to come home, and they should be able to come home with just more resources. Just also to underscore that prisons are places of trauma. The prison itself prisons are not, they're not healing spaces. They're traumatic, and also coming home from prison is another sort of trauma that happens. And thinking about 90, I believe the statistic is 90% of women and trans people who are incarcerated are survivors of sexual violence. And that should be thought about in all of your decisions and all of this commission. And I think like, a thing about the programming too, one of my mentor, Russell Maroon Shotes, who passed away, he did 50 years, about 49 years in prison, and he was sentenced to life. Him and some of his friends had the idea of, so thinking about college, this is again about programming in prisons. There are currently hundreds of programs, college level classes, free, available online. They're called MOOCs, and it's free online college classes. And this is a great resource that could be easily transferred into the prisons. I just wanted to put that idea out there when you're thinking about programming and education in the prisons. And then also just to say like, and maybe those programs could factor into this, the idea of good time bills. I feel like that's part of this commission, is thinking about like time off and how people can earn. Is that part of this? Or is that interwoven in sort of I guess this isn't really a talk back. I do really need a whole training on what these laws could be. But the idea, I know that the idea of good time, so people having access to program and then getting time off their sentences, whether that's they're on parole, or whether that's inside and getting time off. I think those are positive, and everyone should have access to sort of reducing anything that's a part of reducing the sentences. Super support that. And that the idea of algorithms or programmings that can predict somebody's like if they will reoffend again, that highly concerns me. I think that judges should have control and discretion over the individuals who are coming before them. Mandatory minimums and mandatory sentencings they don't work, and they're dangerous, and they don't keep us safe. So, if at any point it should be up to people, not algorithms, not computers, people to be able to have information and discretion to make decisions about people. Again, perpetual punishment does not keep us safe. I really appreciate the opportunity to speak. I'm going to listen because I want to hear what everybody else says, but thank you for the opportunity.
Well, thank you for sharing your thoughts and perspectives on sentencing policy in general. Some of the subjects that you mentioned there are components of them within the sentencing guidelines, and then others are outside the scope of the sentencing guidelines and really apply more to the legislative process. So I would encourage you, make sure, connect with whoever your legislators are, your state senators and state representatives as well, and make sure that, you fill them in on your positions relative to some of those subjects, because I think it would be important for them to hear your perspective on that as well. But we certainly appreciate your testimony. Judge or DA Sunday, do you have anything to add or any questions?
I wanted to add just briefly, it is voluminous information, but a lot recently, I don't know how long it's been that we've been recording our meetings and our public hearings. So, and then also there's a whole website that has all kinds of information regarding the guidelines. And I also just wanted to thank you for your input. A lot of the things that you are mentioning are conversations we have and things that we are considering and goals that we have. So I appreciate your time. And I think DA Sunday maybe has something to add. So thank you.
Very briefly, I just want to echo the remarks from Judge Bernstein and Rep. Stevens. I really appreciate you taking the time to communicate with us and tell us your thoughts generally, even though some of it was sort of out of the scope of what we were looking for today. As a sentencing commission, it's critical that we take input like this into consideration, and we do, as a matter of fact. And I just want to tell you how much I appreciate you taking the time to come and talk to us and to voice your concerns. We can't make the right decisions without input, and you taking the time to do this is very civic-minded. We appreciate it, and that's all I wanted to say.
All right. Thank you so much, Ed. I appreciate it. And again, I apologize for misspeaking your name earlier. I'm sorry about that. All right.
Hey, Mr. Chairman, just a
Yes.
couple comments really quickly, because first, I appreciate the comments, but I also want the testifier to go away with some information that might be helpful. So the first thing is, as Judge Bernstein said, we do have a website. It's pasentencing.us. A lot of information out there. But one thing that may be of interest is we provide free educational seminars about sentencing and guidelines. And because of what we've been through the last couple of years, they're available by Zoom. So feel free to look at the listings there if you have an interest, or if anyone else watching has an interest. A lot of information there and a lot of opportunities to participate in those kind of sessions. So, and they're free of charge. So that's one thing. You mentioned the issue of the ACLU and racial impact, and that's important. And I just wanted you to know that the commission a couple of years ago established what was called an academic review panel that was intended to really look at the guidelines through the lens of race and ethnicity and try to figure out ways to address concerns in that area. And some of these proposals are based on recommendations that came out of that group, especially around the issue of criminal history or prior record score, and trying to reduce the impact of race and ethnicity in how those recommendations are developed. The third thing you mentioned, and the chairman mentioned, was things like programming in the Department of Corrections that we recommend, or things like good time or earned time. And as the rep said, these are really driven by the legislature. They're enacting legislation. But what we try to do as a commission is, when that legislation is enacted, build it into the guidelines, into the proposals, so that courts have some direction or guidance about that. And so whether it's for programs in the State Department of Corrections or programs in the community as alternatives to county jail, those are built into the guidelines. But as the rep said, it's really the General Assembly that has to authorize that. And so talking to your elected members of the Senate or the House is really helpful. And then the final thing regarding the algorithm, the commission does, in fact, have a risk assessment at sentencing. But exactly to your point, the whole purpose of that risk assessment is to identify cases for which we recommend the court get more information, because more information in those cases can be helpful in deciding what type of programming is appropriate, or whether a diversion program is available and appropriate instead of confinement. So I think, the issues you raised are really important. And I think the commission has been trying to address a number of those issues. So I just wanted to join the members of the commission in thanking you for testifying.
I'm going to add one more just brief thing, since one of the things you addressed was discretion of the judge. Is the guidelines are just that, they are guidelines. So it is helpful, the more information, the better for a judge at time of sentencing. But we have the ability to go within the guidelines. We also have the ability to go above or below. So you never lose the human component of receiving information, getting testimony, getting input, and fashioning a sentence. So that is always there and available to the courts. So thank you again. Representative Stevens, I'll turn it back over for you to call the next speaker, I believe.
Right. Terrific. All right, so moving on, next up is Marta Gutenberg.
Chairman,
Yes.
we do not see Marta on Zoom unless Marta is under some other organization. And if so, they could raise their hand under the attendees section and we could promote them to speak. And the same is true for the next testifier, Antoinette.
Okay. All right, so maybe we could we could maybe move on to Kelly Lloyd from the Montgomery County District Attorney's Office. And if either Antoinette or Marta join us, we can just let us know and we'll add them back into the queue. Does that work?
Yes, we will monitor. Thank you.
All right. Good morning, Kelly.
Good morning, Representative Stevens. Good morning, Commission members. Thank you so much for having me. I really appreciate you all taking the time to give us input and the time that you have put in this proposal. It's clear that it's been very thoughtful, and it's very important to us in our daily responsibilities as prosecutors. And I really appreciate you taking the time out of your days to listen to us and take these considerations as you go forward, working on the draft for the sentencing guidelines. I know you've heard from several of my colleagues at the prior hearings related to operational concerns. So I'm not going to belabor that too much. I just would be remiss if I didn't touch on it a bit, because that concern is shared across DA's offices across the state of Pennsylvania, with the fluctuation in OGS based on multiple factors that can be somewhat subjective, such as level of cooperation, taking accountability. Those different factors make it somewhat more complicated for us to resolve cases earlier in the process. And we also have concerns about potential litigation that will come up as a result of those fluctuations. Who determines what is significant cooperation? Who determines what taking accountability is? So more definitive guidance on those would be appreciated. And we're happy to work with you on any of that as we move forward in the process. There are a couple areas of concern that I'd like to address just from my review of the proposal. And the first thing I want to talk about is the lapsing provisions, which we are very much in support of. We believe in incentivizing good behavior, in having a lack of criminal behavior and having a crime-free period. We think that is a very smart approach in the criminal justice system. And so we do support that. The only thing that I would ask that we look at is perhaps some carve-outs as you move forward with the process. Particularly what comes to mind is sex offenses. When you know the likelihood of recidivism for sex offenders, as well as the concerns with delayed reporting because of the trauma that victims experience in those particular areas of crime. So we would just ask that you consider maybe a carve out that would exclude some offenses, in particular sex offenses, from the lapsing provisions that you're putting into place. Another thing that struck me as I look through the proposal is the decreased sentence recommendations for individuals who have violent criminal behavior histories and then are continuing to commit violent crimes. It's not so much, when you have the limited prior record offenses and they're committing a violent crime, the guidelines don't fluctuate much from what is currently in place as to the proposal that you all have put out here. but it's when we're talking about individuals with more significant criminal histories who are continuing to commit violent crimes. And I think we can agree that that's where our focus is. There's a lot of room for discussion about criminal justice reform on other issues and a lot of room for movement. And we believe, like, that's why we believe in the lapsing provision, because we think that that's a good place where we can make that concession and we can reward people for that good behavior. But in regards to individuals who are continuing to commit violent crimes, that's somewhere, that's an area of concern. I put some examples in my written testimony that I submitted with the specific offenses and how the guidelines compare when someone has a prior record score, let's say a 5, compared to somebody that would be a prior record score in the high category under the proposal. And you can see, just as an example, for home invasion burglary, the proposed guidelines give us half of the amount of recommendation as compared to what we currently have in our guidelines. And that's just an area of concern. And I would just ask that we discuss that further and look into that as you continue working through the draft of the proposal. Another area that I wanted to discuss is the lumping of individuals together in certain categories. I'll focus on 2 inchoate offenses and then as well as prior record score categories. For the inchoate offenses, they're somewhat complicated because I find that sometimes, let's use solicitation, for example. When you have a solicitor of a crime, sometimes they are the more culpable person than the person that gets their hands dirty and actually carries out the act. Sometimes the solicitor is less culpable, but to put it into a mathematical formula is quite difficult, I think, because there are so many subjective factors. That is one area that I think a lot of discretion needs to be left to the judge, because of just the factual scenarios make every one of those so different. So that was an area that I would raise some concern as well. And then in regards to the prior record score, when I was looking at comparing some of the current guidelines to the proposal, under the proposal, if you have someone that has a home invasion burglary conviction, just one, or a rape conviction, just one, or someone with multiple F3 retail thefts or one PWID conviction, they're going to be held at the same level for prior record score considerations. And I think we can agree that the level of dangerousness with those offenders is not the same, and they shouldn't be treated the same. So I just ask that we explore that a little bit more as well, to differentiate those individuals as we're reviewing those and making the appropriate sentencing guideline recommendation to the court. And then finally, I'd like to touch briefly on DUIs as well. I think it might be worthwhile to consider a separate grid for DUI cases. And I say that because DUIs are largely underestimated as how dangerous they can be. And I say that because they're the most at risk. The public at large is the most at risk from being injured or hurt by an individual who decides to get behind the wheel when under the influence. And we need to allow for longer terms so that individuals can get treatment necessary to rehabilitate them. And if we're limited to short periods of probation, we may not be able to get what is necessary to try to get to the root of that cause. And so I would just ask that we potentially look at that as a separate grid. I have submitted written testimony, but those are the highlights of what I'd like to discuss. And again, I thank you very much for taking the time to allow us to contribute to the conversation. And I welcome any questions or any working forward with you to work on this proposal. So thank you.
Sure. Thanks so much for taking the time, Kelly. I know you've got a busy job in Montco, and as a Montgomery County resident, I appreciate the work you're doing. And I certainly don't want to take you away from that for too long. Judge or DA Sunday, do either of you have any questions or comments? Yeah, go ahead, DA Sunday.
All right, thank you. Thank you for your testimony, Kelly. It was very helpful. I want to circle back on a couple points that you made, and actually going to the very beginning of your testimony, you said that other people have testified and provided us information, really, and I don't want to put words in your mouth, but on the logistical aspect of this and the implementation within an office. That's not something that I think is a minimal concern. I think that that's a major concern, and it has to be addressed. And so can you talk a little bit, if you can, about what that realistically means to a district attorney's office being able to adhere to the guidelines as proposed?
Sure. So as you know, we're coming out of a pandemic and most offices are experiencing backlogs here, and we're trying to resolve cases as efficiently as possible, work through as many as we can without compromising public safety, of course. And when you look at a system that's going to so substantially and fundamentally change the way we calculate sentencing guidelines, the training required in that, the amount of time that it's going to take. I mean, we're jumping from 14 prior record score category or 14 offense gravity score categories up to 42. And then we've got all these fluctuations that are going to go back and forth with subjective determinations that sometimes we don't have that information until we're way farther into the case. So the ability to be able to generate early pleas is going to be challenged here. The ability to put people into diversion programs could be challenged here. The litigation that is going to come as a result, I've heard discussions of how this is similar to the federal guideline system with the fluctuations in the OGS. I don't practice federally and I have not, so I can't speak to that personally. But I know that there is a lot of litigation surrounding that as to, does this apply here? Does that not apply here? Does the judge determine that? Does the DA determine that? How does that get worked out whenever there's a conflict and a disagreement? So just logistically, in those two areas, those are of primary concern. And it's going to take more time to be able to generate those guidelines, put those offers in files, and get them communicated to defense attorneys. It's just the way that it works right now.
And I appreciate that. And I just want to make it clear that I'm not asking that question as if it's a fatal flaw. I'm asking it because it's just a consideration that's really important because, you know, and if you could, you know, a lot of people don't live in a courtroom all day, right? They don't see the inner workings of what courtrooms are like and litigation on a daily basis. And when I asked a question about the logistical difficulty, in what ways, and I apologize for putting you on the spot, I guess you're testifying so I can, right? But in what ways do you see the logistical problem impacting defendants in cases? And what I mean by that is, when you have ongoing litigation nonstop about what the appropriate guidelines are, how does that impact a defendant?
Well, I would say that they want swift resolution of their cases just as much as we do. They don't want to be dealing with ongoing litigation and having a case hanging over their head for a long period of time. Whether it's they want to fight it, whether it's they want to take accountability, they want swift resolution as well. If they're incarcerated, they definitely are more incentivized to resolve it in the most efficient way possible, but also without compromising, protecting their rights, keeping that in mind, and making sure that it's a fair resolution of the case. And if you have individuals who are already slammed and overworked, I mean, it's really what happens. And then they can't pay the attention that's needed to focus on exactly what needs to happen to make sure that right result is achieved, both from a prosecution end and the defense end. So without definitive guidance and without being able to know what you can offer to defense, and without defense attorneys being able to have clear guidance to be able to communicate to their clients what they can expect, it makes the system more complicated overall.
No, I appreciate that. And that was a great explanation. And I know that wasn't, you know, part of your written testimony, but I know you spend a lot of time in the courtroom and have a lot of experience. So I wanted to touch on that. A couple other things. I don't know if in your assessment prior to today, if you had an opportunity to take a look at how prior 6105 firearm convictions impact the sentencing guidelines. And did you have an opportunity to look at that at all?
I did look at 6105 a bit, yes. What specifically are you looking for?
Just generally, do you have any thoughts on the impact of the proposed guidelines and individuals that have prior convictions for firearms offenses?
Yes. So obviously that's an area of huge concern for us because gun violence is on the rise. We're experiencing it all across the state of Pennsylvania. We're experiencing it here in Montgomery County. And we've got individuals who are felons not to possess. They cannot have guns and they're out there acquiring them and then acting out in areas of violence. We want to have the tools to be able to hold them accountable and remove that violence from the street as much as possible. With the proposed guidelines that I reviewed, they are decreased. The sentencing guideline recommendations are decreased significantly from what we have currently at our disposal.
Okay.
I looked at a few examples as far as what if someone had a prior possession with intent to deliver, or if someone had 3 prior possession with intent to delivers. The more significant the prior record, the more decreased guideline recommendation in the proposal we're seeing as compared to what we have now. And that is certainly an area of concern. And I think I touched a little bit on that in my written testimony as well.
No, I appreciate that, because I know you discussed lapsing provisions, and in particular, we talked about violent crimes, and I think that this is something that we need to make sure we have a thorough understanding of the impact with the proposed guidelines on individuals that have illegal gun convictions in their past. And so I just wanted to just generally see if you had any thoughts on that, and I appreciate you answering that question. The other thing that's really important here is you mentioned DUIs.
Yes.
And I just want you to know that's something that I heard loud and clear. I know that and the average citizen, if you look at crimes, what crime has the greatest likelihood of impacting any of us or our family members on a daily basis? And that very simply is a DUI crash. And so that's the number one crime that could, cause death or serious bodily injury to either us or a family member or people we know in the community. And so I just want to make sure you understand that that's really important. I'm really happy that you provided that testimony with regard to a separate grid. That's something we'd obviously have to talk about. And that's pretty much all I have. So I appreciate your testimony. I thought it was spot on, and it gave me a lot to think about.
Thank you.
Bernstein?
I appreciate your testimony as well. Earlier this week, I guess on Wednesday, we were at Duquesne University and heard from a panel of DAs from a couple of counties, and some of the things that you're raising were things that they also brought to the attention, and particularly the concept of the step up, step down, and how that impacts a fast calculation. So they had thrown out ideas about maybe creating those as almost like a checklist at time of sentencing for a judge to use as considerations in determining where they fall in the spectrum, as opposed to bump ups, bump down. So just to let you know that it's always good. A lot of us, are in various areas of where we practice, but we see so much. And for you who are out there every day, I guess what I'm saying is it feels a little sterile sometimes when we're all just in there talking about it. And then you hear practitioners thinking about, hey, this is how it's really going to have an impact. And sometimes we say, yeah, that's exactly what we wanted. And other times we say, oh, good point. So just to let you know, we've heard that from others as well on those issues. And thank you for your time.
Thank you.
Thanks, Judge. Yeah, we did. So I was not able to participate in the hearing in Duquesne, but I was able to participate in the hearing in Bucks County, which was really terrific in terms of providing insight from the prosecutorial perspective. We had folks from the Delaware County District Attorney's Office, as well as the Bucks County District Attorney's Office there. One of the, and I shared this with that group, and I want to share it with you as well, Kelly, and maybe get a little bit of feedback relative to this. So one of the challenges we have is that with the span of the current sentencing guidelines for some of the ranges. So, and I use the example, excuse me, of a range of 6 to 16 months. There were some concerns about a defendant not really having an understanding of what their sentence eventually would be under our proposal. And I would just submit that under our current guidelines, there's a lot of ambiguity in that same vein. When I look at those ranges, 3 to 12, 6 to 16, that doesn't provide much guidance either. I mean, that defendant with a 6 to 16 range is either going to state prison for, up to almost 3 years, or might be doing a short county jail sentence. And so, I don't know that, I think one of the goals that I have, and I can't certainly speak for the rest of the commission on this, but my own personal perspective is that we ought to do a little bit better job of getting a little bit more granular. So individual offenders are sentenced based on their unique set of characteristics. And by characteristics, I mean the crime that they have, committed and things like that. Different element or different aspects of the crime. What was their role in the crime? Things along those lines. And so it is a challenge, right? We want to get more individualized sentences. In order to do so, it requires really a deeper dive into, every aspect of that crime, and really just provide some more specificity. Another example that I used was the fact that really, when you look at our guidelines, an aggravated and mitigated range sentence can be justified with just about anything. I mean, there really is no specificity with relation to what would provide a mitigated range sentence. So there's no question in my mind that we do need to go back in and define some of these terms better. Cooperation, what will count as cooperation? And I get it that there's a range there. There is, look, you gave, some information and then, police acted upon it, or, all the way up to, you wore a wire, went into a dangerous situation and put yourself at risk in order to take down, a significant drug kingpin. I mean, there's, a vast range of cooperation. And I do understand our need to get more specific with relation to that. I guess my question to you is, in an effort to try to get more individualized with our sentencing, do you see a way for us to do that without it increasing the workload on the prosecution and the defense to really hone in on those specific and granular aspects of each case?
I actually think what Judge Bernstein mentioned, as was suggested at the Duquesne panel, maybe having them be factors at sentencing for the judge to consider might be a better approach in that regard, because then you can still have definitive guidance up in the beginning when you're generating your offer, and then just as sentencing hearings are now, you can present mitigation, you can present aggravation. You're right in that it's difficult because every case is different, right? We evaluate each case on their own facts, and to try to give people individualized, specific guidelines is only going to get more complicated as you add in these different factors. That's how it's going to go. I think the goal, I would imagine your goal is you don't want to see significant departures happening from these guideline categories, because I don't think that we see that happen often now. So if you make them too specific, then you don't want to have those departures then becoming more commonplace because a factual scenario makes this case different than that. That is the one good thing of what we have now is that range that you described, the 6 to 16. We all know, let's say it's a simple assault with somebody that had priors and their range is 6 to 16. A simple assault can be very, very different. It can be a bar fight punch, or it can be a domestic violence that has years of history between the two, where a woman, it didn't rise to the level where she has serious bodily injury, but she's terrified of what's going on. And there's a history of a PFA and all kinds of messy background that can happen. So there might be a state sentence that's appropriate there, or it might be someone that's appropriate for a county sentence. So having that flexibility is sometimes a good thing, but it does leave a lot of ambiguity, as you said, as to what might be the end result. And I don't have the answer to the perfect solution to that. Unfortunately, I think there's always going to be some level of that, just because we're dealing with human beings here and every case is so different.
Sure. No, and that's a fair response, and I think a fair perspective on it. Well, we're going to do the best we can, and certainly appreciate your input, because that'll certainly help us get to I think a better product. So, anything else you wanted to add, Kelly, before we send you on your way?
No, nothing more. Thank you so much.
All right, thank
Representative,
you. Yes, sorry, Mark, I keep forgetting you. Go ahead.
no problem. Kelly, first, thanks for your testimony, and to your colleagues at the other, I guess, 4 hearings we've had. They've been really helpful. And as Judge Bernstein said on Wednesday, I thought we had a great hearing at Duquesne with a lot of these things discussed. Let me just pick up on a couple of things just to make sure I'm clear, where you are. And the first thing is picking up on Representative Stevens' point, the discussion you just had. One of the recommendations the commission received through the Justice Reinvestment Initiative and other groups and other recommendations, I guess, was to have more targeted sentence recommendations, with the idea that we should be recommending a single disposition, not a range of dispositions, and then a tighter duration of that, whatever that sentence recommendation is. And the idea was, first, there are advisory guidelines, and secondly, we should have a common starting point. And third, that should be based on what the typical sentence is, or the median sentence. So that's what we're trying to do. And so to get to the rep's point and your discussion, the commission was trying to come up with recommendations in every case that would point to either probation or jail or prison as the primary recommendation, and then a duration based on that. So I'm just wondering if, based on what you said, I appreciate the having latitude because of fact-specific matters is helpful, but that runs sort of counter to the idea of being more targeted, which is what we've been advised to do by the General Assembly. So any thoughts on that, how to reconcile that?
Well, let me look more into that and come back to you on that, because that is a good question. And if that is what's been recommended to you by the General Assembly, then obviously those are the steps that you're going to take, because you want people to have an idea of what they're going to get whenever they get sentenced. I understand that. It's just, like I said, when you're dealing with human beings, there are just so many factors that come into play that can change the situation very easily from one to the next. That it's sometimes you have the typical offense, but sometimes you just really don't. So if I can get back to you on that, I would be happy to do so.
Sure, that's great. Really appreciate that. And also just to sort of reaffirm what you just said, I think in building these guidelines, which are much more, and these aren't guidelines, these are proposals, but to make them much more targeted, I think the idea is then there may be greater reliance on aggravated and mitigated ranges or use of that to address what are not typical cases. So I appreciate what you're saying there. And that may, maybe we have to look at those in terms of if the recommendation is primarily county jail, maybe an aggravated circumstance would move to lower end of state prison or something like that, or mitigated to higher end of probation. So thank you, I'd appreciate. So here are like 3 quick specific things I'm hoping you can just comment on it briefly. The first is when you were talking about prior record score and crimes of violence, especially violent crimes. One of the examples you were using was home invasion burglary, which is a crime of violence. Now, maybe it's not clear in the proposals, and I want to make sure that we think about this as the commission's moving forward. In the proposal, instead of just looking at selected prior criminal incidents and selecting out offenses, the new approach is to look at all prior convictions, all prior adjudications, except for those that lapse, and then to identify the seriousness of each. So if there was one prior crime of violence, so a home invasion burglary, you're right, that would count singularly, and that might reduce the prior record score, because one of the things the commission was looking at in terms of racial impact and things like that was to try to reduce the general impact of prior record score and sort of move those things to the offense gravity score. But if you look back at a criminal record and there are 2 prior home invasion burglaries, the person now is in revoc under this proposal would be in revoc, which is not the case now. And it would apply for any offense, not just a current crime of violence. And revoc provides for the statutory limit for in any sentence recommendation. So for crimes of violence, I think revoc has been increased dramatically to try to address that as sort of a carve out. And so maybe part of the issue is, is crime of violence, the definition from 9714G, is that too narrow? Should we be redefining what is a violent crime or a crime of violence? Or do we have to think about those first offenses of a crime of violence, that one prior crime of violence, and look at the weighting of that? So I'm just trying to understand your issue, because I think on just the number of prior crimes of violence, the commission has actually substantially increased the recommendation.
In the revoc for the revoc category.
To make people eligible for revoc.
Right.
Yeah.
I would say it's before you get to that point, before you get to the eligibility of the revoc point is where my concern is. So if you've got a single crime of violence, and because I wouldn't equate a PWID with a home invasion burglary. Like I said, if you have one of those, you're in the same category as far as the new prior record score proposal. And that's where I think my concern comes in.
Okay.
Related to.
So all of those sort of being in the same group as one prior is what the concern. Thanks. That's really helpful in understanding that. The second thing is 6105. The commission has an enhancement for any second or subsequent offense for 6105. And so to some degree, it's not the prior record score that addresses the sentence recommendation for a second or subsequent 6105. It's just adjusting what the OGS assignment is for second and subsequent. So I mean, that maybe addresses that area, and we have to look at that assignment for that second or subsequent. But I'd appreciate if you think through, are there any other issues related to firearms that we should be looking at or considering? I think that would be helpful. But I think 6105 specifically for second and subsequent is addressed through the enhancement, and we can adjust the OGS assignment there. So thank you for that. And then the final thing, and you and DA Sunday, and DA Sunday's done a lot of work in your county with DA, with DUI prosecutions, and with really thinking carefully about this area. So I appreciate both of your comments about this, but DUI sentences are really driven by the mandatories. In effect, the only reason they're in the sentencing guidelines is to then add consideration of other prior convictions in the sentence recommendation. But the guidelines really are driven by the mandatory. The mandatory supersede the guidelines. So we certainly should look at the DUI OGS assignments, and we can adjust those, but they're, to some degree that they don't matter much, because
I know what you're saying.
Mandatory. So I'm trying to figure out if I'm missing something on what we should look at with DUI offenses, given the mandatories drive the sentence recommendations.
No, I don't believe that you're necessarily missing anything. It's just because what you were saying, the guidelines don't necessarily matter. That's why perhaps they should be treated in a separate fashion. There should be their own grid for them, because. But
what would that grid offer? What would that, I mean, because if the mandatories really drive it,
that's a fair point.
A point that we don't even need the guidelines for DUIs, unless, and as I said, the commission incorporated them into the guidelines just to make sure that if there were other prior convictions, that would be a factor, a consideration in sentencing that would in effect, create a recommendation higher than the mandatory. So I'm just
That's
trying to figure out what we can or should do.
I think my concern was the limit of the term of probation that could be put on or parole for them. And I may be inaccurate on that. So, but we just want to make sure that there's enough exposure there, enough time to be able to give them a sentence of lengthier supervision to be able to get the treatment needed to address the needs.
Sure, absolutely. And I think, as you know, the General Assembly's been looking a lot at probation caps and other things like that. And to some degree, the guidelines, since they're advisory, was trying to at least, be sensitive to durations of probation. But there again, with DUI offenses, with the mandatories provide the baseline, where probation really comes into play is for those unclassified misdemeanors and, the 6 month stuff. And
Right.
there again, it's not really, we couldn't do much beyond the 6 months that's
Right, we're
available.
limited there.
But thank you, I appreciate that.
And if I may quickly, as I'm listening to, this dialogue, it reminds me of, the dangerous nature of unintended consequences. And I think that it's really important, especially with the absolute danger, and death that's caused by people that are, high, that are drinking and driving. I know in York, over half of our DUIs right now are either drug DUIs or drug and alcohol combined. And when you think about, how dangerous that is, I think that what I'm going to do, just for what it's worth, is, and you referenced earlier, Mark, what we've done in York, and that's the Target 25 program. I'm going to go back through our data, and we're going to do a real deep dive with regard to sentencing for DUIs with repeat offenders. We have a lot of data to determine, we have a lot of data that supports repeat DUI offenders and the likelihood of them causing death or serious bodily injury if they recommit within 10 years, which really has driven a lot of our initiatives. And so we'll take a dive into that. But I really appreciate this conversation because, again, we want to make sure that we get this right.
Well, Kelly, I'm not sure if, you being here, we could probably spend all day peppering you with questions and insights, but we really appreciate you taking the time to join us and offer your perspective.
Thank you so much. I really appreciate your time, everyone.
Thanks, you too. Take care. All right. So we will move on to Cindy Liu from the PA Prison Society.
Good morning. Good morning.
Good morning, Cindy.
Let me see if I can get some more light here. I guess I can't. First off, I just want to make it clear that I'm not representing the Pennsylvania Prison Society. I'm a member, right?
Okay.
But in no way do I represent them or speak for them. So I just wanted to make that clear.
All right,
I
thank you.
don't want them to be mad at me either. So I have to say good morning, and my name is Cindy Liu Miller. I'm also, in addition to being a member of the Prison Society, I'm a prison abolitionist, and my pronouns are she and they. And my testimony today will be primarily speaking about my experiences with state institutions. I testified in Philly last week, and I've been following these hearings, also following all things having to do with prison so-called reform. And although I have not been personally incarcerated, I'm speaking for 6 loved ones that I communicate with and visit in Pennsylvania state correctional institutions. Once again, I'll say that I'm talking mainly about prisons, not county jails. I want to speak to what seems to be a disconnect between the sentencing judges and their knowledge of the Pennsylvania DOC. Many judges seem to be unaware of exactly what happens inside our state prisons. And they're unfamiliar with the locations. In fact, even the pronunciations of some of the prison names. As loved ones of incarcerated people, we hear the stories and we see the evidence on our visits of harsh and racist treatment of human beings and the maze of conflicting rules and regulations and loved ones being sent hundreds of miles away from their families and their communities. And at this part, I think I'm going to read. Allow me to speak of the case of Russell Maroon Shoatz, who was dying of cancer. This is recently, and applied for compassionate release. At the hearing, the judge disallowed his request, as she believed that if he were remanded back to prison, he would receive palliative care. Days later, the case was reheard on an emergency basis, and the judge was horrified to learn that Mr. Shoatz had had no nourishment for 5 days because the DOC was not capable of administering IV nutrition, and they would not send him out for hospice care. The man was starving to death. He had had no nutrition for 5 days. With this new knowledge, the judge immediately released him to his family. And he has since transitioned, he is since deceased. So if the judges could hear the stories of incarcerated people, perhaps it would affect their application of the sentences and guidelines. And lastly, I just want to say that statistics have shown that mandatory harsh sentences do little good. The stated purpose of prison is rehabilitation, not revenge or retribution. Armed with a better knowledge of state institutions and knowing that vengeance does not keep us safer, perhaps the heavy burden that judges bear might be lifted a bit. And that's all I needed to say. Thank you for allowing me to testify.
All right, thank you very much, Cindy Lou. We appreciate your insights and perspective. DA Sunday or Judge Bernstein, do you have any comments or questions?
I just wanted to join in and thanking you for taking the time and giving us that input. Thank you very much.
You're welcome.
And I echo the judge's remarks as well. Thank you for providing that testimony. It's really important to hear from people that have insight, that talk to individuals that are incarcerated and have experienced situations like you have. So I really appreciate it.
All right, thank you very much. Thank you for joining us, Cindy Lou. We'll move on. The next person on our list to testify is Margaret Robertson. Margaret available?
I do see her on the list. I'm trying to promote her to panelist, so just, I'm not sure. Oh. I'm not sure what's going on here. Talk. There we go.
Can you hear me now?
We can.
Okay, good. Thank you so much. I really appreciate this opportunity to speak to you. I did send some written comments, but I'd like to just hit the main points. The first one is that I'm concerned that the proposed guidelines include low-level offenses from some jurisdictions. I live in Philadelphia, and the types of low-level
Hello?
Offenses do not include things that have area, my city. So I'm asking that when you look at that list of non-incarceration offenses, just make sure that it includes things that happen in every jurisdiction all over the state and not just some. And particularly, I'm mentioning one about kosher foods. It's not really a problem in my area. Just make sure that every citizen or every person in the state has an opportunity to get offenses that has an opportunity not to be incarcerated for their offenses. I also wanted to ask that the old guidelines offer a wider range for judges to go from mitigation to aggravation. And I think you may be losing something in denying people the opportunity to make those choices, because I think more experienced judges are more likely to feel free to move around on that range and even outside of it. But I don't know that new judges would feel as comfortable. I really appreciate Representative Stevens' comments about basing sentences on the defendant's unique characteristics. I think that one way you might bring that information into a courtroom would be to tell the defense attorneys ahead of time that these are the things you will be considering, because I have seen some things done in the name of defense that will horrify you. I have seen attorneys who don't know the facts of the case come into court to represent people. And it's clear even to people who are there as supporters, but not really intimately involved in all of the facts of the case, that the lawyers are not prepared. But if you would say ahead of time, these are the things we're looking at, and we expect you to have some response about, I think it would really improve the level of defense being offered in these cases. My third comment is that people don't improve their lives because of the time they spend in incarceration. They improve their lives because of experiences they may have while they're incarcerated. And not all prisons are equally prepared to offer these opportunities. I know the comment Ms. Miller just offered is very true, that judges often don't know what's happening in prisons. And there are some prisons that seem to be much more capable of preparing people for life or a successful life afterwards. And I think you really should consider what prisons are able to do. The same way you wouldn't go to a hospital that has a high rate of mortality in certain types of medical situations, you don't necessarily want to go to a prison that doesn't seem to help you to prepare for life after prison. So I think that should be considered in sentencing. It seems that really judges don't know what's going on. The last point I'd like to make is that you should have people with firsthand experience on the Sentencing Commission. I'm just noticing the folks here today, and I see that I seem to be the only person of color, I'm Black, who's involved in this hearing. I know this is just one hearing, but I really think you're losing access to a lot of information when you don't have people who have had firsthand experience in incarceration and been able to become successful after that. They know what made a difference in their lives. And I really think you should expand the commission to bring this information into the room. I really appreciate the way you are responding to the comments from the speakers. You are really using it as an opportunity to get to know their side of the story. And I think because you seem to be the type of people who want to learn and want to improve the process, I think you'd be well served to bring people who have been successfully through the system into the room. And that is what I have to say. Thank you so much for listening.
Thank you very much, Margaret. I certainly appreciate your comments and your perspective on it. We do have, we have an 11-member commission. There are only 3 of us that are available today. We do have a pretty good group with very diverse backgrounds. We are a group that's made up of, we have representation from a defense attorney. Of course, we have DA Sunday from the prosecution's perspective here. And we have several judges. We have judges from Philadelphia, from Northampton County, in addition to Judge Bernstein. And we also have a judge from Dauphin County. And then there are 4 legislative representatives as well, 1 from the House and Senate, 2 each from the House and Senate, 1 each from the Republican and 1 from the Democratic caucuses. So we try to bring as many different diverse and unique perspectives as we can to the table. But we also do, and I know our executive director made reference about the academic review panel that we recently asked to do some work regarding our sentencing guidelines. And we partnered with some of the historically Black colleges and universities to ensure that they had representation on that academic review panel, because we wanted to hear that perspective from people of color and things like that, as you mentioned. So we do strive to incorporate as much diversity into the commission as possible and reflect it within the body, but also ensure that we are including folks to offer their insights with that regard. We also, as a matter of fact, just to, I know you mentioned including input from folks who are impacted by the system itself. We actually have reached out, and it's really new within the last year or 2, where we are going into our state correctional institutions and having these hearings within the walls of the institution and allowing the those that are incarcerated within those institutions to provide their feedback and input into the guidelines and other aspects of our sentencing practices. So we're trying very hard to reach into every community and hear every perspective as much as we can. So I certainly appreciate your feedback in that regard. Judge Bernstein or DA Sunday, do you have any questions or anything to add?
Just once again, Ms. Robertson, I appreciate your input. And we do hear from so many different people. There are so many different considerations, including, I mean, we're a quasi-legislative body, so we are directed a lot of times in terms of what we're working on, like we are now, but everything that we receive impacts decisions that we make. So we thank you for your time.
Thank you.
And if I may, very briefly, Margaret, this is Dave Sunday. I'm the York County DA, and I've not served on the commission as long as Rep. Stevens and Judge Bernstein. But in my time here, I can tell you that the commission is very thoughtful, that the commission really takes its time to understand how to make our community safer. And sometimes that means reassessing the way that we incarcerate people, and also looking at things like reentry, diversion, and really challenging ourselves to have a better understanding as to how to do this the right way. And so I just wanted to say that to you and thank you for taking the time to talk to us today. I found it to be fantastic, and I thought that your remarks were really important to hear. Thank you.
Thank you all.
All right. Thank you so much, Ms. Robertson, and we will move on to Jasmine Smith from the Snyder County Public Defender's Office.
Chairman, she'll be joining momentarily.
Okay.
Hey, and Mr. Chairman, while we're waiting, just let me make a little comment for Ms. Robertson. One of the things she noted was, or a concern was about not having guidelines or recommendations for some of the more common offenses in Philadelphia. And I'm glad she raised that. It was raised during our public hearing in Philadelphia. And maybe it's just a little bit of a misunderstanding, or we're not clear in the materials we have, but the the offenses that may be more common in Philadelphia are included in these guidelines. They're in the proposals. We have all of the offenses there. Where they fit into the guidelines sort of fall into what the typical sentence was for those. And so I think in Philadelphia, there was a mention that there weren't any offenses from Philadelphia that were at OGS 1, but a lot of those offenses were at OGS 2. So it was maybe a problem in finding them. The other thing I wanted to point out, and this might be helpful for anyone watching, is these guidelines have to be considered by all judges when imposing sentences for misdemeanors or felonies. But the focus is really on common pleas courts, on what we call courts of record. So in Philadelphia, the Philadelphia Municipal Court, or in other counties, the magisterial district judges are asked to consider the guidelines, but they don't have to report them to us. They're not sort of held to the same standard. And so in Philadelphia, there are a lot of cases that are addressed by municipal court that wouldn't show up in this information or in our analysis because they don't go before common pleas court. So I know that's sort of in the weeds, but because it was raised in Philadelphia as well, I just wanted to make sure you were confident that we have considered all those offenses. They're in all of the work that we do. And if there's any suggestions about changes to what we've done with those, that we certainly are open to that. So thank you.
Thank you. I didn't understand that.
Great, thanks.
All right, so we'll move on. I see Ms. Smith has joined us up here. Thank you so much, Ms. Smith, for joining us. And the floor is yours for your testimony.
Thank you. I wanted to take an opportunity to thank you all for allowing this to be a public forum where we could voice some of our opinions as to the proposed changes to the guidelines. As already stated, I am the Chief Public Defender of Snyder County. Excuse me, my experience has always been as a defense attorney. I've been practicing for about 3 years as a public defender in more rural counties here in Snyder and in Northumberland. And so my comments will be related to the fact that 1, I'm a defense attorney, and 2, I do practice in very rural areas. And so it won't be some of the same concerns that may have been brought up by those who practice in more urban areas. I was asked by a member of the ACLU to take a look at some recent cases that I had and sort of I apologize, yes?
Oh, no, sorry, I lost you, and I wasn't sure if everybody else lost the audio there or not, in particular our court reporter, so.
Sorry, one of the benefits of practicing between cornfields is terrific service.
Yeah, it's funny, even though I'm from suburban Philadelphia, I speak to my colleagues very often about the broadband challenges outside the southeastern portion of the state, so I appreciate it. If you could maybe just start over again.
Okay.
That would be great. Thanks.
No problem. I am Jasmine Smith. I'm the Chief Public Defender of Snyder County. I've been practicing for about 3 years, so my experience has been as a public defender in rural areas, Snyder and Northumberland County. So my comments may be somewhat different than those practicing in more urban areas. Excuse me. I was asked by a member of the ACLU to compare some recent cases I've had under the current guidelines and then compare them to where they may fall under the proposed guidelines. And my written testimony highlighted one specific concern that I had and then gave sort of a background as to a current recent case I've had to illustrate that concern. That being that some of the proposed enhancements from a functionality standpoint, I am responsible for explaining the guidelines to my clients, where they fall in the guidelines and what those consequences realistically mean for them, especially if they're considering a plea. Obviously, most cases do resolve in a plea. There's benefits to both sides and most situations to resolving without a trial. But the guidelines have to be functional and I have to be able to explain what a person is facing in order for them to competently decide how they want to resolve their case. And so one of the concerns I had dealt with enhancements. In my experience, because of where I practice and live, the 2 most common enhancements that I see that are not grading enhancements due to subsequent offenses are either domestic violence or deadly weapons enhancements. And so those enhancements are somewhat objective. They it either was a deadly weapon or was not, or it was a domestic violence incident or it was not. One of those are discretionary. And so typically in negotiations with the Commonwealth, we can work with that in some way, or at least make comments to the court that they not apply that enhancement. Deadly weapons, while not discretionary, again, typically in negotiations with the Commonwealth, we can either negotiate to a charge where it's already included in the offense, and so the enhancement will not apply, or simply the enhancement will apply, and this is what your guideline will be with that enhancement. That's a little easier to explain because they're more objective. But in my testimony, I used a recent case where the proposed enhancements are not as objective, and I would not be able to explain to my client whether they applied or which enhancement applied. Specifically, I had a case where I had a client who resolved his case with a plea to 1 count of possession of child pornography. However, the original charge, when I got the criminal complaint, had 10 counts of possession of certain images. And that was before we got to the preliminary hearing. There was an offer and a discussion with the Commonwealth before we ever got to the preliminary hearing for what the offer would be, discussed it with my client. My client was cooperative at every standpoint throughout the case. But prior to the preliminary hearing, there were 10 images based on the proposed enhancements that would put him in a particular category for an enhancement at that point. At the preliminary hearing, because the investigation was still ongoing, there were more images that were found. The Commonwealth was not interested in adding more counts because there was no disagreement as to what the end result of the case would be. And so when the information was filed, it still had 10 counts. And the plea was for 1 count. My concern with the proposed enhancements is that there's no context as to when we determine if that enhancement would apply. And so between, and I forget the specific ranges, between a certain number of images, the offense gravity score would increase somewhat. And then again, there would be some step up. I think actually it's a step up, not necessarily an OGS increase under the proposed guidelines, but there would be some additional consequence depending on how many images were involved. But I would not know or be able to explain at what point we determine how many images were involved. Is it at the time that the criminal complaint was filed? Is it based on what is filed in the information? Is it based on what we're pleading to? Or is it based on what was uncovered under the investigation by the time we get to the plea hearing or the trial, depending on however they move forward? If I can't explain that to my client, I can't tell them what the potential consequence is, and that affects their ability to, one, decide what they want to do. That could be to their detriment if they decide, well, if I'm looking at all of these enhancements anyway, there's no benefit to me pleading, I may as well just have the jury decide my fate at that point, which could be to their detriment ultimately, because there's no negotiation power as to sentencing after a trial. There's only leaning on the mercy of the court, essentially, and making certain arguments before the court as defense. But so that was my concern with some of the enhancements. Also, I don't know, based off of the proposed enhancements, how, and I have the same concern for some of the statements that were made earlier by Kelly from the prosecutor's office in terms of, I guess, incentivizing individuals to cooperate or have accountability for their actions. I don't know how much the proposals made by the Sentencing Commission sort of encroaches upon processes that already exist for us to address those same concerns. So in negotiations, we can address situations with defendants who are, let's say, cooperating with the police if they have a drug charge, who are accepting accountability. Things like that are discussed during negotiations, at least in my experience, discussed in negotiations with the Commonwealth, and determining what we're willing to work with in terms of a plea. And so in my experience, we take those things into account when we're crafting a plea, or at the very least have the opportunity to make those arguments before the court when the court decides on what is an appropriate sentence, even under the terms of the plea agreement. And so I don't know if some of the proposals specifically, like I said, the enhancements and the incentives, how much they are necessarily necessary in the proposed guidelines because they already have a role, although it is not a role that is implicitly clear when evaluating the guidelines. And as a person that functionally has to explain the guidelines to other people, I don't, although it is jarring to go from a scale of 14 OGS to something much larger, I don't know that there's additional work in doing that, but I have to know what I'm explaining. And I don't know that the proposed guidelines, at least in the areas that I've indicated and some others have indicated, are truly functional and allowing me to explain what they mean specifically to a person. And so those were primarily my comments. I will go on forever if I don't force myself to stop, so I'll stop there.
Sure. Mark, do you have any comments about the enhancement conversation there, and particularly as it relates to pornography cases?
Sure, and thank you, Public Defender Smith. That was really helpful information. Let me just mention that under the current guidelines, we do have the child pornography, the sexual abuse of children enhancement, because it's required by statute. The commission was required to create it. And so we just tried to build it into this new framework that we've been putting out there for public hearings. I think with all of these enhancements, what might be missing from the proposals is the starting point is a conviction offense. That's how the sentencing guidelines work. And so everything that you've talked about in terms of negotiating pleas and determining what's in and what's out and so forth is as it is. The guidelines only start once you have a conviction offense or a negotiated plea, and then these factors apply. So I think, in the testimony today and also in previous hearings, there have been a lot of concerns about the sort of the logistics and the timing and the practicality of this. And as Judge Bernstein indicated, maybe one of the ways to try to address this is to make really clear that these kind of considerations of enhancements or adjustments in however they're fashioned happen at sentencing based on a determination by the court, which is how it works now. And it's intended to work that way under any new guidelines. But I know when we put forward this idea of these adjustments, sort of like the federal system, it introduced this thought that it's happening, early on in the process. And clearly those things are going to be discussed and negotiated, but the determination about what applies and how it applies is made at sentencing, just like everything else with the sentencing guidelines.
All right. Judge Bernstein or DA Sunday, do you have any questions or anything else to add?
Attorney Smith, thank you for your testimony. Quick question for you. One of the things that came up that we've had concerns about would be the potential increase in litigation surrounding sentencing outcomes under the proposed guidelines. Do you have any thoughts on that, just from your spectrum?
Hello?
Can you hear me?
Yes.
I apologize. I apologize. I heard that there were some concerns as to pending litigation following a sentencing under the proposed guidelines, but I didn't hear anything after that.
No, I'm just saying, do you have any thoughts on that from your side? Like, one of the concerns that we had, that I have, is inundating the system with appeals or challenges to the sentence once this is done, and I just am kind of thinking through how this would work practically and what the impact would be on your clients, on the system, and so do you just have any thoughts generally on that?
Generally, I think that there's always a concern of an inundation of appeals whenever there's any significant shift and how we process sentencing cases, et cetera. And so I think that's a real concern. And I think there is a potential where clients could see this as an opportunity to file appeals based off of the discretionary factors that are now available to the courts when determining a sentence that may not have existed in the same way that they existed before. And I agree that we run that risk where if there are more discretionary factors at sentencing that the court can take into consideration and weigh, which they already have a lot, and we know that the court makes the final decision. But again, as was stated before, things such as a level of cooperation or a level of accountability, yeah, I could foresee that there will be clients that say, well, I think I cooperated substantially and the court disagreed and I want to appeal because I think that they made the wrong call on that.
Well, what about under the Post-Conviction Relief Act? Do you see any issues or opportunities for individuals to challenge, their representation via PCRA as a result of the potential difficulties that you raised with regard to determining what an outcome would be under the proposed guidelines as you're speaking to a client? Do you have any thoughts on that?
I absolutely do think there's a heightened potential of clients saying, well, my attorney never explained that I had this potential or that I could get this much time. And if I had known that, then I wouldn't have made the decision that I made, which is often the argument for PCRAs. But I think that the concerns that I have about understanding what I'm explaining to my clients makes that a much better argument when it's the truth. I didn't explain that they had the potential of XYZ because I didn't know that was a potential for them.
No, I appreciate that. That's very insightful, and I'm glad that we were able to kind of have this conversation in front of the commission. And I just want to say, and I said this earlier, these issues that I'm raising about what this will look like in practice, they're not necessarily fatal flaws to the proposed guidelines, but it's critical for people to understand, the hurdles that practitioners face and the potential, adverse effects on defendants and on victims. I mean, if cases have to come back repeatedly through PCRA and things of that nature, then victims, are re-victimized as they go through that process. And again, I appreciate having you articulate that. I thought that was really helpful, and so thank you. Yeah.
Thank you.
I just want to reiterate one of the last comments from Sunday I kind of was trying to indicate that before, that some stuff looks good on paper, and then when people start saying how it's going to apply. So we very much appreciate your input.
Thank you. I appreciate, again, you guys having this forum for people to be able to speak and discuss some of the functionalities of something that will affect all of us, even though we have very different, I think, challenges in terms of sentencing. For instance, I've never seen a school zone enhancement applied in my practice because they're not everywhere. I'm sure it's different in Philadelphia, but it does have to apply to the whole state, and the opportunity to have different perspectives given is a good one, and I appreciate the opportunity to participate.
Ms. Smith, I chuckled when you said that because I remember a conversation occurring in my county where the reverse was true. I think that at one point they determined the entire county was a school zone because of the proximity to bus stops and everything else like that. So it's a different, certainly a different and unique perspective that you bring to the table. So I appreciate it very much. Thank you for your testimony.
Thank you. I do have to go, unfortunately, but I appreciate you all allowing me to speak today. Thank you.
Take care. All right. Ryan or Mark, have either of the prior testifiers joined us?
They have not.
Okay. All right. Well, then I think that concludes everybody who has signed up to testify for this hearing.
We can check if there's anyone else that's requesting. We don't see anyone. Last chance.
All right.
No.
Well, look, I just want to thank everybody who joined us today, either to testify or just to listen. We certainly appreciate.
Mr. Chairman, we just got a hand.
Okay.
Mr. Chairman, it'll be Alan Lewandowski.
Okay, terrific. Mr. Lewandowski, the floor is yours.
Cool, thank you so much. Whoops, let me get my camera. I don't know why it's not on. Well, I'm having trouble getting my camera to work, and I apologize for that.
It may not be you. I'm having trouble like promoting you to panelists, but we can still hear you. So.
Okay, I see it now. Okay.
Mr. Lewandowski, are you still there?
Appears he has disappeared.
He's still showing up on my screen.
We have him back now.
Oh,
Thanks. All right. All right. Can you hear me?
we can.
Okay.
At least I
thanks a
can.
lot. Okay. Once again, I was just saying I appreciate that you all have this panel, that, you know, you're doing this work. You put all this time into it, and that you're including community voices. I think it's really important, you know, to go along with all of your expertise, you know, in really addressing Pennsylvania's public safety. So thank you all very much. As you know, someone who also, like some of the other people have testified, work with many people who are incarcerated and have particular interest with people with life sentences. I mean, that's going to color my commentary. And I guess I have a question, you know, it's like existentially, how do we measure the success, you know, of good sentencing, you know? And there's a lot of reason in Pennsylvania, especially in the last 40 some years, to think that, you know, leniency in sentencing and also range in sentencing, and primarily having an opportunity for people to hit a minimum earlier rather than later. It could be a way of, you know, addressing, you know, kind of the aggressive move made by prosecutors in Pennsylvania, you know, since the 70s and 80s to drastically increase the prison population. I mean, it's hard to have a conversation about sentencing if we don't start by saying Pennsylvania prisons grew from 10,000 to 50,000 in population between, you know, the early 80s and the 21st century. So sentencing has had an effect on that. And as someone who visits people who have served long sentences, like 30 years, for instance, almost all of them are ready to come home. They're not a threat. And in fact, I'm being humble, but I mean, I think we all can be. These people have put in the work to become human beings that some of us have not done that level of healing yet. And they have a lot to offer to our society. And they also have a lot to offer to people, other people who are incarcerated, because if they're included in programming, they rub off on people. That sense that I've taken radical responsibility for my actions, be it small, be it though I was marginally connected with a crime or not at all connected, maybe I'm innocent. People have taken this radical responsibility to say, I'm going to make myself the best I can be. And we've seen on short-termers who have come out and 16 years later are crediting the lifers that they met and saying, this is why I've started this reentry house. This is why I'm out here thriving, because I was in programming with long timers. It is that important. And I think that, like I said, if people are getting a second chance, a second look earlier, I think, you know, the aggression that really drove the rise in prison population, it can be mitigated. And I don't feel public safety is enhanced by 6 people getting conspiracy charges, being labeled as violent offenders, and getting life sentences for a murder that one person committed, you know, just because of a zeal to show numbers of successful prosecutions. And the other thing that does is really clog up getting down to solving the real issues. For instance, some people have mentioned it would be good for judges and everybody, reps, and you all to know who's in prison, because there is such high numbers, people are allowed to languish with serious mental health and psychological health issues in RHUs across the state for 10 years, 13 years, 17 years. And their reason is not complying with programs, but they're having a mental health crisis. And so it's a major catch-22. And we could address serious issues like that if we could reduce the population. And I think if you get to know long-termers, you can see that some of this aggressive sentencing and call for public safety is not being, it's not having the desired result. That's my only input, and I appreciate you all for being here and for what you're working on. And yeah, hope this works out for all of our good. Thank you.
Thank you so much, Mr. Lewandowski. I appreciate it. DA Sunday or Judge Bernstein, anything to add there?
I'll jump in here real quick. I just want to thank you for your testimony. I think that a lot of the topics you covered are things that collectively everyone in the justice system is acknowledging that can be done better. I know that there's a tremendous amount of work. I'm involved with the DA's Association on pretrial diversion. I know in York, we have a robust reentry coalition. The DA's office, I mean, we're co-chairs of that. And so a lot of what you're saying is not falling on deaf ears. And I think that the commission and the staff have put a tremendous amount of work into identifying a way to have our sentencing guidelines be more fair under all the circumstances we face. I mean, these are very tough issues. I mean, we're talking about human beings and victims and crime, and but what I can tell you is that, please know that we acknowledge that public safety and ensuring public safety is not always lockstep with putting people in prison and throwing away the key. There's data, there's evidence to support smarter ways to do things. And that's really interwoven into this commission and the way that we process these problems and think about it. And so I just wanted to make that clear, and thank you for your time today.
Thank you.
All right.
Again, I just wanted to thank Mr. Lewandowski for his words as well. Thank you.
Thank you all.
All right. Thank you so much. We appreciate it. All right. I believe that concludes our hearing today. Am I right, Ryan and Mark?
That's correct. Thank you.
All right. We appreciate everybody who offered their insights and those who didn't, but just were curious and interested enough to spend some time with us on this Friday morning. I hope everybody has a happy and healthy and safe weekend, and we will see you at the next hearing. All right. Thanks, everybody.
Thank you.